plates come, and try not to be too disruptive, please. For those of you who don't know me, my name is John Rogitz. I'm the president of the Lawyers Chapter of the Federalist Society here in town. Before we get started, I'd like to recognize the Thomas Jefferson chapter and Fletcher Morgan in particular for helping us out with this event and co-sponsoring with us. So as you probably know, we're here to discuss the constitutionality of President Trump's immigration order. We have two panelists here today. We have Professor Josh Blackman of South Texas College of Law and Professor Wenger of Thomas Jefferson. Professor Blackman is an associate professor of law at South Texas, as I said, in Houston, he specializes in constitutional law, the U.S. Supreme Court, and the intersection of law and technology. Josh is the author of the critically acclaimed book, Unprecedented, The Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. Josh was selected by Forbes magazine for the 30 Under 30 Law and Policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's an adjunct scholar at the Cato Institute, and he is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS.
Fantasy SCOTUS.
There you go.
You got it.
The internet's premier Supreme Court fantasy league. I didn't know. I'm into fantasy everything, and I didn't know that one.
I'm on the ball.
Yeah. Okay. Let's see, where was I? Oh, he also blogs at joshblackman.com. He leads the cutting edge.
That's enough of an introduction.
All right, let's do it. Professor Wenger is an associate professor here, and he's also the director for the Center of Law and Social Justice. Professor Wenger's research focuses on a variety of civil rights topics. His scholarship has appeared in the Wisconsin Law Review, American University. Forget it? All right, okay.
And we're good friends too. We've known each other for some time now.
All right, thank you. Got it. So I think we're good then. Let's
go
for it. Yeah. Oh, I'm sorry. Hey, Randy, I didn't see you walk in. Randy Burholtz is here as well. He's going to moderate this. He is an adjunct here and very distinguished in his own right. But since we're cutting the introduction short, we'll just leave it at that.
Let's roll.
Yeah.
Well, thank you all. It's a pleasure to be here in San Diego. I haven't been in San Diego since I was 5 years old. And my only recollection of San Diego is my parents took me whale watching. And it sounds like a great idea, but when you're 5 and you're on the open seas and you see no whales, you're not happy. So my only recollection of San Diego is unhappiness, but this is a much happier occasion. I'm also Professor Wenger, and our good moderator, for taking the time to appear. I'm grateful for the opportunity to talk about the Supreme Court's upcoming decision concerning the constitutionality of the travel ban. But before I get to that case, I'd like to discuss another case which you may have studied in constitutional law, the case of Texas versus Johnson. This case considered whether a person could be arrested for burning an American flag at a political protest. The decision broke down on a 5-4 line, but to the surprise of many, the deciding vote was Justice Scalia in favor of the flag burner. Now, Scalia was no fan of flag burners. He once said, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag." But Scalia said, "I am not king." Indeed, Scalia felt the answer was compelled by the First Amendment, even though he disagreed with the result. Texas versus Johnson is a good gut check for lawyers. If your understanding of constitutional law overlaps entirely with your philosophical beliefs, you may want to reassess the former. This is much how I feel about the travel ban. I'm a libertarian. I generally favor open immigration policies. I think the idea of banning the entry of aliens from certain nations merely because those countries have been associated with terrorism is an awful policy. These executive orders will cause hardship to families, refugees, and others who are simply seeking a better life. I'm also doubtful this policy will do much to improve our national security. Yet, with my cards on the table, I'm firmly convinced that Congress gave the president the power to take these actions. And the Constitution does not bar him from exercising the powers in the manner in which he did. So I'll try to address 5 points. First, I want to walk you through the history of the travel ban, including statements by then-candidate Trump, as well as statements made by now President Trump. Second, I will discuss the contents of the 2 executive orders, both of which have been halted, at least in part, by the courts. Third, I will discuss whether Congress has afforded the President the authority to take these actions from a separation of powers perspective. Fourth, I will discuss whether these actions are conflicting with the First Amendment, namely the Establishment Clause. Finally, I will give you a preview of the Supreme Court's upcoming arguments on October 10th in the case of Iraq v. Trump, and breaking news, we have an order from the court last night on this case. They knew I was coming here, so they gave us an order last night. So our story begins long before Donald Trump as president was even a glimmer in anyone's eye. Back in December 2015, then candidate Trump called for, quote, a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. Over the next few months, Trump shifted his position from Muslim ban and moved toward what he called extreme vetting of people from certain territories. Or did he? Cue PolitiFact, right? During a July 2016 interview on 60 Minutes, Trump told Leslie Stahl that you can still call it whatever you want, but we'll call it territories, okay? Was that a repudiation, or was it a wink of the nod to make right? However, a week later, on Meet the Press, Trump seemed to clearly repudiate the old policy to Chuck Todd. He said, I'm talking territory instead of Muslim. Trump is not good for coherent sentences. It's a fragment of sorts, but did he really mean it? Or was this fake news? Alas, the burden of reconciling these statements has shifted from fact checkers to the federal courts. And since January, a number of judges have parsed these various statements and others to determine the president has an animus, that is a hatred of Muslims, which infects or taints, if you will, the actions that he's taken. Okay? So let's talk about the actual orders which were issued. One was issued in January of 2017, about a week after the inauguration. The second was issued in March 2017. So the first one sent shockwaves, was chaos. It said, for 90 days, aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen were deemed detrimental to American interests, will be denied entry to the United States. And then for 120 days, the refugee admission program will be suspended. I am not going to talk much about refugees. I want to focus on the travel ban. Almost immediately after the order was signed, chaos began. Because people who had gotten on planes overseas with proper paperwork, as they were in the air flying across the Atlantic or the Pacific, the policy changed. So by the time they got to the airports, they were stuck. And you may not know this, but even when you land at an international airport, you are not yet on U.S. soil. Can we get food afterwards, please? Thanks. You're not on U.S. soil quite yet. You're not on U.S. soil until you get out of the airport, which is an important thing. So what happened is all these people got stuck in the airports, and judges, I think correctly, issued writs of habeas corpus and let them out. Eventually, courts enjoined the travel ban, and the Ninth Circuit Court of Appeals, in the case of Washington versus Trump, said this is unconstitutional. The government did not appeal that to the Supreme Court. Instead, a couple weeks later, on March 6th, the government issued a second executive order. It had some changes. It removed Iraq from the list of countries that were barred, and it made clear that green card holders, as lawful permanent residents, would be allowed to enter. And also, rather than saying that these aliens themselves are dangerous, what the memo said is that the government of the United States lacks information to verify that these people are who they say they are. Okay? This policy, too, was challenged in court, and courts in Hawaii and in Maryland issued what amount to global injunctions, forget nationwide, global injunctions barring the enforcement of these policies. Those decisions were appealed to the Supreme Court, and the Supreme Court issued a series of orders, not on the merits, but on whether the policy can go into effect temporarily. I'll get to those orders in a bit, but the bottom line is the Supreme Court on now 3 occasions has pushed back, at least in part, on the Ninth Circuit's rulings. Now, let's move into the third part of my talk, which focuses on congressional statutory authorization. Okay? Congressional statutory authorization. We have a statute, 8 U.S.C. 1182F. It's 50-something years old, and it says, whenever the president finds the entry of aliens or any class of aliens into the United States will be detrimental to the interests of the United States, he may ... suspend the entry of the aliens, right? So if he deems certain classes of aliens are detrimental, he may deny entry to that class. Everyone with me? Okay. There's another statute that's relevant, and it's a statute that denies nationality-based discrimination with respect to the issuance of visas. Okay? It actually doesn't bar religious-based discrimination for visas, because much of our immigration law is premised on treating people differently based on their religion, but we'll get back to that later. How do you reconcile these two statutes? One denying entry, the other about visas. These are different concepts. This may be a surprising thought to you, but even if you enter the United States at an airport with a valid visa, they don't have to let you in. I'll give you a really easy example. You show up at SFO with a proper visa and you have Ebola. Okay, you're not going to be let into the country. You show up at the airport and you give maybe misleading answers to the agent, and he says that the information you put in your visa is not valid. You're not getting in. And in fact, you don't get a judge or a hearing. You get turned around right away. You get put on a plane and sent home. It's actually a very, it's called expedited removal, basically. You're sent right back. The government has long seen that entry and visas are different concepts. So long as the government's not revoking visas, which they aren't, the entry ban, I think, stands by itself as giving the president the relevant statutory authority to act. But that's not the whole enchilada, right? That's not all of it. You also have to consider the Constitution, because even if the president has the statutory authorization to act, if it's unconstitutional, statutes are relevant, right? So what are the arguments that this policy, this travel ban policy, is not only ultra vires statutory, but unconstitutional? Okay? The primary argument advanced by the various courts has been the Establishment Clause, right? Now, it's something of an odd fit for the Establishment Clause, because this is not like your traditional case. They're not putting up a Ten Commandments monument in a courthouse, right? They're not trying to say prayer in school. The argument is actually this, that by President Trump instituting this policy, he is expressing disfavor of Islam. That is, he's favoring some religions over others, he's just favoring Islam. And the justification for this is based on statements he made before the inauguration, which I quoted a couple of them before, as well as some statements he made after the inauguration. As a threshold matter, though, one of the questions the courts have never addressed is, does our domestic Establishment Clause case law even extend to the immigration context? I don't think the answer is necessarily yes. I think there's a good chance it doesn't, and I'll give you a few examples. While in the United States, if Congress passed a statute saying that pastors will get special benefits, right? They'll get special tax treatment, they'll get special permissions to do various things, well, maybe that's good, maybe it's bad, right? But overseas, if you are applying for a visa and you're a pastor, you get special dispensation. You jump to the front of the line. If you're an atheist, you get bupkis. Another example. We have statutes in the book that give special treatment to, quote, Christians and Soviet Jews. That if you were a Soviet Jew or an evangelical Christian in the former USSR, you were given special priority treatment. Now again, if Congress passed a statute saying we'll give special benefits to Jews and Christians, God, the ACLE would be on in 5 seconds. But the point I'm trying to make is much of immigration law, especially asylum law, has a strong entanglement with religion. And if we start applying our domestic Establishment Clause case law to foreign policy, I think a lot of other provisions would probably fall. But I'll assume for the moment that we simply can apply our foreign policy, our domestic case law to foreign policy. I'll assume just for argument's sake. Even then, I think the courts have overreached. So first, the courts have cited President Trump's statements on the campaign trail. Not his statements after inauguration alone, but on the campaign trail. There is no precedent for this whatsoever. Politicians routinely lie on the campaign trail. It's part of the American experience, right? That's the thing, they lie and they do something else when they get to office. There's also an important fact that when you take the oath of office as president, it's transforming, right? I've described it almost as a baptism of sorts, right? Perhaps not in Trump's case, but in general, you cleanse yourself of your prior position and you become the commander-in-chief, the leader of the free world. And I think that has significance. Another problem with signing campaign statements is it eliminates the fact that Trump may have gotten advice that what he wants to do is illegal. And there's actually good evidence of that fact. Now, we all know about Rudy Giuliani, that he had this commission, and he said, oh, tell me to do it legally. But do you know who else was on the commission with Rudy? Former Attorney General Mukasey. Representative McCall, who chairs the Homeland Security Committee. There was actually a committee put together to figure out how to protect national security. And they decided, Mr. President, you cannot do a Muslim ban, that's illegal. But you can do a ban based on territories with this statute recited. Now you'd say, well, that's not the real reason, this is really just a Muslim ban. Okay, fine. But the actual policy itself is facially neutral. And that's an important fact. The policy itself doesn't say we're discriminating against Islam, it says we're doing these 6 countries. Now, I'll concede. Those 6 nations are predominantly Muslim. But there are a lot of Muslim nations not on the list, Saudi Arabia among others. Now you may say, well, Josh, this was actually based on security. Why isn't Saudi Arabia on the list? The 6 countries that were selected were from a statute signed into law by President Obama saying we will not give people from these countries what's called a visa waiver, right? They'll have to apply for a visa when they travel here. So they didn't pick these 6 countries out of the air. They got them from a body of case law. Okay? So at bottom, right, you have a facially neutral policy with a very strong, I think weak, but it's, in terms of the courts, it's an articulated national security interest. And this is not adequate, this is not sufficient to enjoin the president's policies, especially in the realm of national security. Okay? Now, I want to move on and talk about the Supreme Court for a bit. So the Ninth Circuit, the circuit that we're in, they've issued a number of opinions in the last few months. And in each instance, the Supreme Court has said, not quite, try again. The government has had fairly decent success at the Supreme Court, not much success in the lower courts. And I'll give you a data point, right? In 3 occasions, Justice Kennedy has gone along with staying in the Ninth Circuit. In almost every case where Justice Kennedy issues a stay that puts the lower court on hold, he ultimately reverses, right? I found one exception, it was a death penalty case. But generally speaking, when Justice Kennedy issues a stay, it means he does not agree with the lower court. So that's not good news for the challengers. So on October 10th, next month, the Supreme Court will be holding arguments in the case of Iraq v. Trump, that's the International Refugee Assistance Program, and Hawaii v. Trump, which is another case from here in the Ninth Circuit. And they'll consider all these issues. They'll consider whether the president has a statutory authorization. They'll consider whether the president has the constitutional authority. But there's another issue that could potentially end the entire case, which is a doctrine that you know that learned about, mootness. You know about mootness, right? So recall that President Trump's initial policy way back in January. Feels like a lifetime ago, doesn't it? It really does. So way back in January, Trump's initial policy called for a 90-day suspension of entry for certain aliens. Well, that 90 days never even lapsed. I think they got maybe a week or 2 before the court stopped it. Okay, so then we go to March. Trump again asked, I want 90 days of the travel ban, right? 90 days of the travel ban. He didn't get the 90 days either. He got maybe a couple days, if that. But eventually the Supreme Court intervened and said, okay, you can implement this in part, right? Some can be entered, some can't. So technically the clock started ticking for some aliens, but not others, which raises the question, when does the 90 days run out? By some measures, the 90 days runs out at some point, I think the end of this month. End of this month, give or take. I'm not very good at math. I went to law school, right? By other measures, the clock never started ticking, so the case isn't moot. So perhaps some will argue that the Supreme Court should duck the case altogether, and so we dismiss it. Now, the effect of dismissing a case that became moot on appeal, which is important, is you vacate the lower court decisions. So the Ninth Circuit's decision, the Fourth Circuit's decision are vacated. They're wiped off the books. As one else say, they might be persuasive, but they're not precedential, right? But there's another argument that the case should not go away under what's called the Voluntary Cessation Doctrine. Now, I'll give you an example. Let's say you're the chief of a police department and you've been accused of police brutality over and over again. Happens. And then the chief goes to the judge, Your Honor, tomorrow we're going to stop brutalizing people, so dismiss the case. And the judge says, I'll see it when I believe it. So even though you voluntarily ceased this activity, right, you told me you're going to stop it, I'm going to keep jurisdiction to make sure you actually follow through and stop brutalizing people. Good idea, right? I think a similar argument pertains with respect to the travel ban. Even if the Trump administration withdraws this policy, the underlying claim of animus remains, right? The challengers have said that your immigration policy is infected, is tainted by this hatred of Islam. and as a result, we will maintain jurisdiction. So I am not convinced the court actually dumps the case, even if they could. Maybe they'll want to, I don't know. But I'll end here, I'll give it over to Professor Wenger in a minute, by saying that the court really should address this sooner rather than later. Because this argument of looking to the president's statements to determine his state of mind is somewhat novel. And I actually have a piece coming out in the Wall Street Journal tomorrow on this very issue concerning DACA. You didn't think I would talk about that, right? DACA, another issue, right? So last week, your Attorney General sued the Trump administration saying that the withdrawal of DACA is illegal. And the New York AG and UC Napolitano, they all sued, right? And one of their arguments is very much the same, that Trump hates Mexicans. And that's the reason why he withdrew DACA. He has animus towards Mexicans. They said it. And some of the evidence they cite are statements Trump made on the trail. Bad hombres, remember? Yelling at Jorge Ramos, right? Murderers and rapists. You'll remember these awful comments. But the New York AG and the California AG have said that these statements are evidence that Trump hates Mexicans. Therefore, his withdrawal of DACA is illegal. Now, there's a gap here, right? At least with the travel ban, Trump was talking about Islam in the same context. Here, he's talking about MS-13 and the border wall, whatever crap he's talking about. There's not the same line between pardoning Joe Arpaio and withdrawing DACA as there is between the Muslim ban and the travel ban. So I think they're asking a limiting principle, which the court, I think, needs to articulate. That judges can't just scroll through Donald Trump's Twitter feed, find any of the stupid things he says, and use it to strip him of his lawful authority. I think these are statements that you could pause before you vote for Trump, but I don't think that they're justifications to withdraw the authority he has, both under the Constitution and under the statutes. Thank you so much. I'll turn to my dear friend, and maybe I'll have some Q&A afterwards. Actually, do you want to make food first? Yes. Go get a great. I'm so sorry.
Everybody, please reach out to the great leaders. Slider salad.
What's going on? How you doing?
Good. How you doing?
Good. Good to see you.
Yeah, you were walking with the little puppies the other day.
Yeah. That's Dalton.
That's random. Well, we're in the same neighborhood, so we're like right into each other.
Oh, I didn't see you though.
We were driving by.
Oh, okay.
Quiet, and he's got a puppy. I didn't know he had a puppy.
Yeah, that's Dalton. He's about 2.5 years old now. His little terrier makes of some sort. Yeah, I just had to take him for a very quick walk on the way over here.
Yes, good, yeah. Which one is
Get whatever food you're going to get, finish what you're going to get. You're going to start in just a few minutes because we won't have time for Act 2.
That's all right. Yeah, that'd be great.
Excuse me. If I could have everybody's attention, please. If you parked in the park gate today, please come see me on your way out. I've got parking vouchers for those who RSVP. So if you parked in the Padres park gate today, I've got some parking vouchers. We didn't get out, so please come see me on your way out. Thank you.
I'll get some people later. I never like last time. There you go. All right, everybody, if we could please find our seats. We're going to start here in 30 seconds, so
Thank you all. And Professor Wenger, I will leave it to you.
All right. So, welcome back. A big thanks to the Federalist Society for setting this up. It's a fantastic topic. Big thanks to Josh for coming out to present here, and to all of you for attending. So, one thing that my students know that I've talked about, that I talk about frequently, is the importance of facts. So I talk about how, for instance, when you're talking about Guantanamo, that you look at the Supreme Court opinion and you've got the majority and the dissent. And the majority says, 1,000 years ago, the right of Magna Carta, habeas corpus, King of England, and then you flip to the dissent, and the dissent says there are dangerous Muslim people who have been killing Americans for 30 years. And as soon as you look at the facts, you know how each side is going to come out. One of them is talking about rights of habeas corpus and this shouldn't be taken away in thousands of years, and the other side is talking about exigent circumstances. And so when I was clerking, my Judge Weinstein on the federal bench, liked to say that by the time you got to the end of the fact section of an opinion, you should know how it comes out. You shouldn't even need to read the law. So I think this discussion in some ways illustrates that, because the facts, as Josh Blackman points out, are absolutely accurate, and yet there's a few that I would choose to highlight slightly differently. So additional facts that one might choose to highlight in assessing the issue. We've got an array of statements from candidate Trump and then President Trump. On CNN, Islam hates us. On NBC News, there's no assimilation. They want to go by Sharia law. The one statement that President Blackman mentions, but then we've got several others. I would certainly look at the idea of closing mosques in the U.S. Trump's floated the idea of creating a database of Muslims. So these are facts that suggest there might be more than just one or two individual comments here and there, facts to suggest, and of course the keyword, the buzzword, the A word, right, animus. What is animus? And Professor Blackman is absolutely right to point out, first off, that animus case law is a mess. Animus was sort of like, it's cobbled together in part because, for those of you who remember from your common law class, we don't have, well, our existing system of constitutional law is a little bit weird. It's based on categorization into protected categories, and then if you're in the, if you're in the race category, you get strict scrutiny, but if you're not in a protected category, you get rational basis. And then back in Romer, Justice Kennedy says, oh, let's give rational basis a little bit more, so let's also add to it. Some people refer to this as rational basis plus, where it's not rational to create a law just because the legislators hate a group of people. Or because lawmakers hate a group of people, or have animus towards that group of people. Animus case law is not particularly well developed, and it's not all that clear how it fits into the existing framework of, do we fit into a protected category? If so, we get a certain degree of scrutiny. Animus is kind of a wild card. We have a new additional wild card, which may or may not be the same wild card, which is dignity now. And there are open questions about how dignity fits into the framework as well. So on all of those points, I absolutely agree with Professor Blackman that this is an area that has some uncertainty. But when we look at the history of these tweets, and when we look at another set of facts, which are also accurate facts, which will be highlighted on this side of the opinion or dissent rather than the other side, the rollout, where the Justice Department has no idea what's going on as the president is making announcements about new policies, and then you have airport standoffs, U.S. congressmen, U.S. senators being told you can't go and talk to people in airports. There is, for what looks like a brief period of time, the distinct possibility that there will be a throwdown between federal marshals and TSA agents on the ground of Dulles Airport. This suggests something unusual going on. This is, at the very least, not the normal way of rolling out an executive policy related to immigration or anything else in the history of the country. So, as we look at those sets of facts, we have to say, based on what we know about animus, do these facts suggest that this policy was created due to animus? And I'll agree with Professor Blackman that the statute and case law gives a lot of deference to the executive. That if the executive were to hold a meeting and say, we have decided that immigrants from the XYZ region of the world have a greater incidence of horrible diseases, and they need some sort of special disease screening, there's all sorts of precedent for that sort of thing. There's all sorts of precedent. We see President Obama used the powers, President Clinton. These are not uncommonly used powers by the executive to set immigration policies. So the argument that folks, including me on blogs and Facebook and now in this, are making is that this is not the normal type of immigration policy setting. Instead, this is something unusual, and the unusual seems to be driven by the A word, animus. So let's talk about what happened with our process here. First off, President Trump told Republican voters, I'm going to do things about Muslims, that Muslims are a problem, and I'm going to do things about these Muslims. From there, he switched to promulgating an executive order which appears to have been written on the back of a napkin, sort of quickly tweeted out, and then let people pick up the pieces from there. This creates chaos, of course. Ironically, it doesn't do the stuff that it's supposed to do. That is, he says this is an executive order to create a small grace period during which we can figure out a reasonable, thought-through, clarified, articulated policy, which hasn't happened. So ironically, that sort of also suggests that the original statements about what it is were pretextual. That is, if I say, if we see a case like Romer, the statute doesn't say we hate gay people, we hate gay and lesbian individuals, we want to keep rights from them. But when you look at the statements that are made, when you look at the effects, then the Supreme Court says, actually this looks like it is the product of animus. And similarly, when we look at this, if it's true that the house is on fire and we really need 90 days to create a sensible policy and work it through Congress, then why haven't we been creating a sensible policy and working it through Congress in the grace period that has been created as these have been on hold? It appears that Trump's statements about needing this grace period were a pretext to cover up the statements of animus, to cover up the background of animus. Now, it's also true that a lot of the things that Trump is doing in the executive order are things that could be done legally if they didn't have an improper purpose. So it is legal to say we're going to set certain caps on regions of the world, we're going to create policies, we're going to create vetting policies. All of these are things that, as Josh Blackman points out, are built right into the statute, as long as they're not based on discriminatory and animus-based I just completely lost. As long as they're not based on animus, we're just going to stop there. So let's briefly go through a couple of other things, and then I do want to turn the time over for some Q&A. First off, so we've talked about lawless rollout, we've talked about tweets. One thing that several people have argued, including Professor Blackman on his blog, if you haven't looked at it yet, you should. It's excellent writing. joshblackman.com, also on Lawfare, right? Is that Trump, the tweeter, is different than Trump, the head of state, and that Trump's tweets should be treated as
I call the commander tweet.
Yes, commander tweet, and they should be treated as just so much hot air. This is fascinating because there's a school of thought that talks about the president is a unitary executive. The president is, even if you can't find congressional intent because Congress is 100 different people, 535 different people, the presidential intent is actually pretty easy to find. And I do agree that maybe not all statements should be seen as commander-in-chief speaking with commander-in-chief hat on, right? If he says, I think the Yankees are going to win this game, that's not necessarily the commander-in-chief speaking as an organ of the United States government. But if he says, we're going to pass laws and those laws are going to affect people who are Muslim who are coming to the United States, that's pretty different. And I think, to some extent, let's give his remarks the space that they claim to be. If he's saying, this is my policy, I don't think it's too radical for the courts to say, well, that looks like that's his policy, because our number one witness on the stand is President Trump himself, saying this is my policy and this is why I'm doing it. And of course we part ways on this because, and because I think a reasonable argument can be made that the president in tweet does the tweeting things, but I think that broadly speaking, when you look at the rollout, when you look at the number of statements made, when you look at the apparent disregard for that pretextual statement, the fact that there hasn't been any push for a congressional clarification, that this starts to look more and more like a case of animus. And of course, animus right now is still in the I know it when I see it land. We don't have a good test for animus. I don't know if we want to test for animus because the tests for existing common law stuff tend to devolve into really, how thin can you slice the bologna? And so maybe animus should remain and dignity should remain, and I know it when I see it land. But to a number of folks, to a number of scholars, and to a number of lower courts, this has seemed like animus. It may be that the U.S. Supreme Court calls it animus as well. Remember, they haven't actually approved. They've simply said we're going to unblock it for now, which then has this complicated sort of question about mootness. I mean, it may go to a capable of repetition but evading review sort of standard. What if President Trump issues a whole bunch of exploding orders? For the next week, no Muslims. Okay, now for the next week, no Muslims. And by the time any of them get into court, they're all expired. That could be a problem. So yeah, I think the Supreme Court may want to hold on to it to keep that from happening under a capable of repetition and evading review, as in Roe v. Wade, as in other mootness cases. But broadly speaking, I think we've heard a great articulation of reasons why people might not believe it's animus. I think the reasons to believe it's animus come directly from the horse's mouth. I pledge to kick out all Syrian refugees, certainly look at closing mosques, strongly consider creating a database of Muslims, total and complete shutdown of Muslims entering the U.S. I think Islam hates us. And the final statement where he says, this is animus, ha ha ha. No, he doesn't actually say that. So, turn the time over for a Q&A now.
Yes. Well, let me take moderator prerogative here. So, we've had two professors. Sorry, you professors, you both like to talk, and you're both talking like this. So I'll do a couple of things. One, I think, is as somebody who spends a lot of time bringing people together for settlements, I'm going to ask you a couple of questions, and then we'll throw it open. So first thing is, trying to find out what you two agree on. So maybe we can hit that first. So Congress makes the laws on immigration, correct?
Correct.
The president has to enforce the laws on immigration, correct?
Correct.
Okay, and Congress has ceded some authority to the president for national security purposes to be able to limit foreigners who come into the United States, correct?
Correct.
Okay, so now that's what you agree on. What you disagree on, let's go down to travel ban. So, Professor Blackman, so right now you believe that President Trump's executive orders on immigration for the travel ban are constitutional. Is that correct? Okay, Professor Wenger, so you believe that they're not because of animus?
Yes, because of animus, because they appear to be motivated by animus rather than the stated reasons by which they say they're motivated. If laws are based on animus, those laws are not constitutional. So because of that, I believe these are not constitutional.
Professor Blackman, would you have a...
Well, I spent 30 minutes talking about it.
Oh yes, but
I can't restate
sense or
it.
two.
No, I can't go restate it in 15 seconds.
Okay.
I think we do it in Q&A would be good. If we're running a little bit short on time.
Okay, well, let's hit that. If we can for a second. So, okay, so let's go to Q&A if you like. So,
Yeah.
what time do we have to finish?
We have about 10 minutes.
10 minutes. Okay.
Thank you.
Let's have Q&A on the travel ban part.
Thank you.
Absolutely. Let's just see some hands. We'll try to get to as many people as possible. I'll just come around and hand off the mic and you may ask a question.
Mine's a future question. If this animus theory holds, do we then look at Senator Byrd, who used to be a KKK official, and bar him from voting on civil rights matters? Or where's the end of it? When do the courts Where do they stop? Can Dianne Feinstein be barred from voting on Catholics this week? That's the question.
Sure, good question. So animus is a thinly theorized theory at this point. It's appeared in a handful of cases. It has appeared mostly in cases regarding anti-gay prejudice, but it has also appeared in Lukumi talking about questions of religious prejudice. So right now it is, I think we're both agree, it's thinly theorized, but to the extent that legislation appears to be based on trying to target a set of people for some characteristic, that is not a rational basis.
Right, so the issue here, and I think Judge Kaczynski, who I'm sure all of you are familiar with, he's a Ninth Circuit judge in near LA, and he made a quick one of his opinion saying, can you look at a candidate's high school yearbook, see if he's anything stupid in his high school yearbook? We've all said bad things, and I think I agree with Kemi. Yeah, there's a litany of statements I didn't mention so short on time, but there are some pretty awful things. I draw a very fine line between statements prior to inauguration and after inauguration. I think statements made after inauguration are fair game. I absolutely do. The statements after inauguration are pretty tame. Maybe that's because this lawyer's got him and said, you gotta shut up. Maybe because he wasn't running for office, although he's probably always running for office. Or maybe it's because he said, wow, I'm president now, I can't tell people to shut down mosques. And I'll hold out hope that perhaps a person can actually improve upon taking an oath of office. I do firmly believe that. But if we start going down the route of looking at statements made before office to create the taint, and I know you're all familiar with McDonnell Douglas, right? Washington v. Davis, burden shifting. I'm not applying it to the commander-in-chief. There is a very significant office here that I'm not applying normal law to, that the president usually gets dispensation. And Kevin made, I think, a good point. He said, this is not normal. I'm with you, right? We are beyond normal. And there's this concept in the law of presumption of regularity, right? This is the notion that, generally speaking, you treat the government as acting in a regular fashion, okay? The courts have abandoned the presumption of regularity for Trump. I think that's inappropriate. Now, any court's going to abandon this presumption, let it be the Supreme Court, right? Let the Supreme Court say, okay, Mr. President, we're standing up to you. But you know, so far on 3 occasions, the courts have pushed back. On 3 occasions, the courts have pushed back. Yes.
I don't think it needs a microphone. So if we have animus, let's take it the other way and see how it works the other way. So let's say, pick out some ethnic group, religious group, person of color, and say, you know, I really love those people. I really love those people. I think we should keep them in chains, in slavery, because you'll help them out. And all we try to do is help them out. Now that's not animus, is it? So shouldn't we take that same kind of concept of what people say versus what they do and apply that? So let's get rid of the 13th Amendment, for example.
So it's a good question. Certainly, mostly we don't see laws that say this law is based on the fact that we hate a particular group of people. That would be a pretty clear-cut animus case. In fact, when we look at Arbor laws did not say we hate gay and lesbian couples, and in fact often were framed in language of positive reinforcement. We want to encourage our gay and lesbian brothers and sisters to marry straight people so that they have straight relationships, etc. In ways that were not phrased as we hate gay people. Nevertheless, Justice Kennedy saying this is based on such a profound disagreement with the person's internal values that you're saying we reject their identity as a gay or lesbian individual, and Justice Kennedy saying that is animus and that is a loss of dignity for those people. Dignity is
I'm glad you're talking about Kennedy's opinions in Romer. Those are equal protection / due process. It's unclear exactly what we think that. Since the beginning of the travel ban litigation, I viewed this case as a matter of due process, right? Does the government have a rational basis to act? I think this stuff at the Establishment Clause is window dressing. If you want proof of this, look at the DACA suits, right? Religion, it's not saying that Trump is getting rid of DACA because he hates Mexican Catholics, right? He hates Mexicans, right? Is there an irrational basis? Is there a animus, as Kennedy keeps using, I think, the correct word? So if the court says to the lower, if Justice Kennedy says, all right, lower court, you can find animus from President Trump by searching his Twitter feed, Godspeed, right? It's open season, the presidency's over. He will not accomplish anything. Every one of his actions will be joined by the courts. That scares the crap out of me, right? I would agree with his actions. I think all of his policies are very stupid. I would not support a travel ban, but he was elected. In fact, elected on making these sorts of idiotic promises, which, by the way, he hasn't kept. Obamacare, right? There are a lot of promises he has not kept. He did not keep almost virtually any of his promises, right? Besides some executive orders, right?
Professor Wenger, if you were going to advise President Trump then as to how he could make a travel ban legal, how would you do it?
So that's exactly what he asked Rudy Giuliani, right? He said,
Not just Giuliani, though.
Right, yeah, he asked his panel, he said, I want to sanitize this. It's a good question. So on the one hand, Josh has an approach where you get baptized on the day of inauguration. I don't think that holds up entirely. I don't think I could walk up to the stand just before getting inaugurated and say, I'm going to pass a law because I hate Muslims. I'm going to pass a law because I hate Muslims. I'm going to pass an anti-Muslim law because I hate Muslims. Put my hand on the Bible and then say this law has a pretext of national security. I don't think that would be okay. So somewhere in between, the point is, I think what we need is some sort of neutral party. Okay, so actually I teach corporations, this is what we do. When we say like, I need to make a sale to another company that I own, or I'm a CEO or a board of directors, I step out of the room. We engage in what they call a freshening. We have a neutral, a disinterested, fully informed third party take a vote on typically the other board members, and when that happens, it removes the potential taint of self-interest. I think once Trump has made all of these statements, it's hard for him to step out.
Is the taint forever?
Is the taint? That's a good question.
Is it a forever taint?
I wouldn't call it a forever taint.
Could he absolve himself by, I don't know, like going to a mosque and praying? I mean, what would it take for him to actually absolve himself, in your opinion?
That's a good question. Some sort of statement indicating disavowing the prior, if it's unanimous.
Would that be enough just to disavow it? If he came out and said, you know what, I didn't mean it. I take it all back. I sincerely, Donald J. He tweets it. I, Donald J. Trump, rescind and disavow all of my statements. Would that be enough?
That's a good question.
And I think that the reason I'm asking the question in that fashion is because if he can't ever disavow it, then what the hell's the point of this presidency, right? He's pissed off everyone, right? Muslims, Hispanics, right? Jews, I mean, he's pissed off everybody. Is there any group that he hasn't offended?
All white guys.
All white guys.
So, and I guess, we're back to animus being, and I know it when I see it. And it traces back to the deeper problem that existing equal protection and due process jurisprudence has problems, it's full of holes, which is why Justice Kennedy created animus to try to patch up problems with the existing footnote 4 structure, but the fix has to.
We have 3 minutes left. Okay, over there in the corner.
The thing that intrigues me about all this is just like our adventures in Iraq and Afghanistan. We make a claim. Now, Trump ran on the premise that he was going to protect America against the Muslim terrorists. And whether you call that animus or not, you look at which countries were banned. And it's a strange list. And one of the leading exporters of terrorism, the major supplier of the terrorists who supposedly bombed 9/11, Saudi Arabia.
Right. Yeah.
But Saudi Arabia is not on the
list. I mentioned this, I think earlier, the reason why these 6 countries were passed is because they were countries that President Obama added a similar list last year. But I agree, Saudi Arabia's absence is incongruous.
It just happens to be interesting that there are several business dealings.
I knew you were going to say that. I always get that question. I knew it was going to come.
Between Trump, his family, and his business ventures in Saudi Arabia.
As the official other side on this, I recognize, but I don't find it credible. I think, he has enough money that he doesn't need to appease whatever few millions that he's getting from Saudi Arabia. So I don't think that, at least I haven't seen any evidence that has driven this particular policy. I think there are a lot of problems with this particular policy, but I don't think it's driven by whatever small advantages.
Right, I think we have time for one more question in the back. Yes, sir. That one, sorry.
It's an animus. Let's assume that there is an animus. That's not a prohibition on the action.
Right.
It applies to scrutiny. In this particular case, it just seems to me kind of obvious, particularly when you're in a national defense and national security context, that it passes any kind of rationality, even if you assume animus. You start by saying, Well, if I've identified someone who I think is an enemy to my country, it's natural for me to have animus. If I can't, if that disqualifies it, then security is gone. But the second thing is, whether or not I like these people, I make a judgment as the executive that if I let in 1,000 of them, one of them's going to be a terrorist. And in my judgment,
Want to wrap up, get to the question, we have a minute left.
in my judgment, that's a trade-off. Isn't that sufficiently rational to support the orders, even if animus was admitted?
Sure, and this goes to the question of, what is the level of acceptable error? There's a great piece by Eugene Volokh on this about, N guilty people, right? You go to the Bible.
Sasha Volokh, by Sasha, yes. Yeah.
Yeah, you go to the Bible, in Abraham, they will spare the city if there's 50 righteous people. Well, about 40, how about 30, how about 10? How many sort of terrorists, if we have 1 in 1,000 and we're saving 999 lives, is it still rational to say we're going to keep out this, Wall Street? There's a lot of good bankers there, but there's a few Bernie Madoffs. Let's lock them all out of the country. At what point do we want to limit the ability to say guilt by association?
Isn't that an executive decision rather than a judicial one?
We'll see. I think we're out of time. Thank you all so much for your attention.